We welcome you, sir, in today's session
Thank you.
on public interest litigation in India. So, about Dr. Hardik Parikh. Dr. Hardik Parikh is Head Training Division and Assistant Professor of Law from Gujarat National University. Dr. Hardik has also remained an Assistant Professor of Institute of Law near my university. His areas of interest are intellectual property laws, business laws, and constitutional laws. Dr. Hardik has published various number of research papers on intellectual property laws and other laws as well. He has participated in number of international and national seminars and conferences. Besides, Dr. Parikh has organized as well as participated in various capacity building training programs and faculty development programs from time to time. And he has also been honored and awarded for his academic excellence as well in the past. So today, Dr. Hardik Parikh sir will start our session, and they will deliberate on the topic public interest litigation in India. We have divided his topic into two parts. Today's public interest litigation 1, and tomorrow the same speaker will shed light on public interest litigation part 2. Sir, you may start now.
Yes, sir. Thank you so much. I hope I'm audible and visible.
Yes, sir. Yes, sir.
Yeah, okay. Hope I'm audible and visible. Thank you so much for
Yes, sir.
providing me opportunity. Thank you, Kashmir Law College and Yaha sir most particularly, as well as Dr. Kalpesh Kumar Gupta for inviting me and giving me this platform to share some of the views on public interest litigation, which is one of the most interesting and emerging issue or topic in our country. And I'm very happy to share that in collaboration with Pro Bono India also, we have done some of the certificates course earlier also for our law students for legal aid clinic at GNLU, as well as the Pro Bono associates also. And the experience has taught us that the topic is always elaborated in two different days. One day is completely dedicated for the theoretical discussion and legal provisions, that how the jurisprudence has evolved. And second day, more particularly, we are interested to know about the practical aspect, including drafting of PIL, where to approach, how to approach, what points should be considered, how we are going to draft. So these all things are becoming very important based on experience, and that's why I think we have calculated 2 days for discussion on public interest litigation. So I'm sharing my screen, and let me know once the screen is visible to you and all the esteemed audience. Yeah,
Yes, sir.
is my screen visible, sir?
Yes, sir.
All right. Fine. So, before we begin, I think that the entire audience of us today are from the law students as well as the practicing advocates also, and some of the people who might have joined for the knowledge, right? So, to what extent public interest litigation would have been discussed with them? Any raw idea can I get, sir, in case any one of the participants can have, so that we can make it interactive and we can go directly to the point as well as required. Yeah, the law students who are there in the session today have studied this topic in their law schools or as per the curriculum. Yeah, am I audible? Yeah, can we have a little bit interaction if possible in beginning?
Yes, sir. Why not?
Yes. Yeah, if anyone is able to please answer, I would be very happy, so that we can avoid the repetition as well as the theoretical discussion, and we can discuss more practical aspect which is actually required. How the PIL started, what is the jurisprudence, what is a legal provision available for that, how PIL has become a very important piece of justice protection today in our country. Anything? All right. So I always discuss with this particular basic pillar of democracy, which is including three broad organs: that a legislature, which is divided again as central legislation, state legislatures, and then a parliament divided into two different houses: Lok Sabha, Rajya Sabha, and followed by the president's assent. Main task of legislature is to make the laws for our nation, and different laws which are enacted by the legislature in terms of their particular uh, powers of legislative competence are getting used or are getting particularly implemented through the executives. All right, am I audible? I think the video connection is disconnected.
Yes, sir, you are audible.
Yeah, okay, okay. I got the message about network fluctuation and I think video got disconnected. That message I have received. All right. So, legislature and second executive, who is having a task of implementation of the different legislations. Now, where the role of judiciary comes into picture. Yeah, do I have? Can I have one or two answer, please? How we see judiciary? What is a role of judiciary as a pillar of democracy in our nation, which is comprised of Supreme Court, High Court, and lower or subordinate courts at the grassroots level, where the litigation will start. So, how we see judiciary?
So basically, there are two aspects. One, that judiciary keeps a check on the working of both the legislature and
Yes,
the executive,
yes,
and another, that it safeguards the fundamental rights of the public.
excellent, right. So if you minutely observe, very nicely identified, there's a very popular sentence by Lord Denning: power tends to corrupt and absolute power corrupts absolutely, right? We might have, and all law students would have heard this particular sentence so many times. In case the faculty member is discussing with them, what is the meaning of that? When we talk about legislature and executives, two powerful bodies are there: the power of legislature, MPs, MLS. We understand that it's a law making power, which is something very fascinating and which is giving a lot of edge, that whatever will be decided, that will be considered to be the rule of the nation. It will be required to be followed by all the people, and executives will be implementing. Now there is always a question that what if the legislation as well as executives have done some of the task, and that task would have resulted into some of the deprivation of the rights of the public. It is not always necessary that powerful authorities would always work for the betterment of the public. In some of the cases it is absolutely correctly identified. Like, what if the legislature has come out with some legislation which is going against the letter and spirit of the Indian constitution, more particularly when we talk about article 13, which is talking about the pre-constitutional laws, post-constitutional laws, and it has been very clearly mentioned: the state shall not enact any law which takes away or abridges the rights granted by Part 3 of Indian Constitution. Where you will go? Number two, executives, where we have so many times complaints that the powers, policies, and different kind of legislation which are enacted by the legislature are not implemented in a proper spirit by executives. Then what? Like, take example, that government came out with the scheme. There's a wonderful law in our 2013 for the nation that's called Food Security Act. I am sure every one of you would have heard about that. That in order to assure that the people would not go hungry stomach before they go to bed, the government will plan to provide the free or of subsidized rate of the food grain at the rate of 1 rupees kg, 2 rupees kg, 3 rupees kg to the poor people in our nation. Now this is a law which is passed by the legislature. Now the task is on executives. Now what if tomorrow 10 people from the slum area is going and standing in a queue of ration, and executives say, we don't have ration for you, just go away, we don't have. Now how to get ensured that their rights get protected? And that's why this sentence again comes as a again and again in our mind, that power tends to corrupt, absolute power corrupts absolutely. And that's how the role of judiciary comes into picture. Let me tell you, my dear friends, that role of judiciary is every time discussed, elaborated, criticized, as well as the appreciated also by the upcoming. And today we are all connected with the social media, and by virtue of the internet connectivity also. So many times the judgments delivered by the court, maybe High Court, Supreme Court, is always having some of the vision they are discussing is going on, and that's how the judiciary's role is considered to be the very important. And in the topic of public interest litigation, it's also role of judiciary which has proactively identified. More particularly, we talk about the role of the Supreme Court of India and various high courts. Obviously lower courts are not coming directly into preview of the public interest litigation, and that's why what is meaning of public interest litigation, let me tell you. The Indian constitution or legal system of the nation is not defining public interest litigation by any legislation unless and until Supreme Court came with a series of judgments, and then later on some of the guiding rules framed by the Supreme Court of India and various high courts, which is now defining public interest litigation. But ultimately, from the Indian constitutional inception, like in the year 1949 when Constitution of India was enacted, and 1950 when we got adopted the constitution, the no concept of PIL was not at all available. So today it has been, I have given some small example or a definition, that it is called a litigation filed in a court of law for such protection of the public interest, such as pollution, terrorism, road safety, constitutional hazard, etc. Maybe any kind of work which is basically connected with the public interest, which we are able to define, and any matter where the interest of the public at large is affected can be restricted or redressed by filing a public interest litigation in court of law. So this is what, based on the practice, based on the entertainment of the litigation taken by court, this definition has been available. As I told you, it is not defined in any statute or any act, but it is interpreted by the judges to consider the intent of the public at large. Now here I would like to know from some of the students, can you tell me that which articles judiciary used in order to entertain the matter relating to public interest litigation, and how this particular interpretation came by judges? Yeah, can we name some articles, please, which are used time and again? Do we have any mechanism in Indian constitution that this kind of public interest litigation will go to this court, then any appeal can be filed before this court, this will be the procedure? Any kind of legal provision have we seen? Yeah, see, generally the articles of Indian constitution, we are taking always reference of article 21 of Indian constitution, read with article 32 of Indian constitution, and when you go for high court, 226. Now see, what is the speciality? Article 21, if we read, it has been broadly mentioned right to life and liberty. No person shall be deprived of his life and liberty except according to procedure established by law. And now Article 32, which we have already discussed earlier so many times, which is giving you that in case of any violation of the right or any kind of rights granted by Part 3, the person may go to courts by invoking the writ petition. And then 5 writs are mentioned, including the writ of habeas corpus, writ of mandamus, writ of certiorari, quo warranto, and prohibition. Now here, when you see that any person who is having any problem with the fundamental right can go to court, but what if the writ jurisdiction, as by virtue of the normal writ, is not available? And then the broad literal interpretation has been given that even though person is not able to follow the proper channel, we are going, and that's why this example or this particular concept I have mentioned, that we call public interest litigation as a rule of relaxation of the rule of locus standi. Now, can anyone tell me what is meaning of locus standi? What is locus standi? Which provision of the law is providing that it is a locus standi rule? You might have heard the petitions, or you might have heard the court hearing, right? Nowadays, the High Court and Supreme Court of India is putting live telecast. Just before I started the session, I was listening to one of the interesting case which is going on in Gujarat High Court. And when court is asking the advocate, what is your locus? Why your client has approached us? What is the locus of your client? Do you understand? Can anyone give me what do you mean by locus standi? Yeah. I hope you are okay if I am telling you to interact.
Locus standi is actually the legal standing on what basis you have come before the court, and what are the legal points on which you rely, and
Exactly.
you are. Yes.
Exactly. Wonderful. If you see under CPC, there is a very provision that suit of civil nature, who can file the suit, right? And similarly, when we see the writ petitions, you are always finding the different kind of the provision that whenever a person is affected directly, he should have to have a legal ground. What is a particular stand of that person before the court of law? You can understand this point in a way that if I have a stomach problem, I need to go to doctor so that doctor can check me and can give me medicine. I cannot take a power of attorney on behalf of my brother, on behalf of my father, and go to court and say, sir, my father has given me power of attorney and please give me the medicine. That's not possible, right? Because the way doctor and medical profession is connected with the individuality or individual disputes or individual pain, the legal system is also. Now, this is very interesting law. Why? Because you should not entertain any petition on behalf of someone else. Otherwise, the person will keep identifying other person who may not be able to go directly to the court, and then courts will be flooded with this kind of petition. So in order to avoid the people not at all connected with the law or not at all connected with the violation of rights are not entitled to come to court, and that's how the rule of locus standi work. Now we can ask that whether the rule of locus standi is a positive or negative aspect. I told you it's a positive, that it will help courts to limit the litigations, but it is also negative. We have heard so many times that if there is a violation of right, suppose there is a X is a person who is violating right of Y. Now Y is unable to go to court because of multiple reasons. He may be poor, he may be illiterate, he may be with any kind of legal knowledge, he may be person who is not willing to go to court and whatever. Now he will not take any action. Now that will give encouragement to X, and then he will do the same thing with Z, same thing with A, same thing with B. So what has been seen in society, that if you are not allowing anyone else, and if the person who is affected is not going to court, then the wrong things will keep repeating, and thousands of times we have seen this example. And that's why, in order to implement the spirit of Indian constitution, that the rights of the people should be protected, judiciary took a call. For your kind information, we always remember name of two judges for development of the jurisprudence relating to public interest litigation in India. Can I have the name? In case you are aware, you can write down in comment box, or in case anyone of you would like to unmute and answer, I would be very happy. Who are the judges whose name is always taken, yeah, when public interest litigation jurisprudence is developed in India? Yeah, I could see someone is trying to unmute and answer. Yeah, I would be very happy to get an answer, please. Yeah, can you name the judge, please? All right.
Justice
You are
Krishna Iyer and Bhagwati. Justice Bhagwati
Yes.
and Justice Krishna Iyer.
absolutely correct. Wonderful. Yeah. So Justice Bhagwati, Justice P.N. Bhagwati's name is always okay, we are taking in order to entertain the petition in even in form of the particular postcard. And Justice Krishna Iyer, and then always we are taking name of advocate Sri MC Mehta, who has thousands of cases which are there on the name, and multiple times you might have heard in a advocacy academic syllabus also. And that's how the concept of judicial activism comes. Now here I would like to tell you something about the judicial activism. And then rule of locus standi, which I told you, I have elaborated here, that only he can take recourse of the jurisdiction whose own legal rights or personal property are directly or substantially injured. No, we are using the word directly and substantially, right? I have already spoken this, but sometime when you are unable to read because you might be joining from mobile, I have already explained this, and later on this presentation will be shared with you so that you can always look it together. When a person challenging administrative action is a total stranger, the court will not ordinarily entertain the petition because he doesn't have any kind of right. And therefore, a country like India, where there are multiple situations, like we have poverty, we have ignorance, we have illiteracy, fear. No, most important point, that have you heard every time in Gujarat, basically, I can tell you that when I take, because I take a lot of classes in a local language. In local language, people tell me in Gujarati, I will translate that into Hindi, कि साहब हमें तीन कपड़ों से दूर रहना सिखाया गया है बचपन से. एक काले कपड़े, दूसरे खाकी कपड़े, ब्राउन कपड़े, और तीसरे सफेद कपड़े. Right? They are telling that we are required to afraid from three color clothes: black, khaki, and white. You don't want to go to doctor because you don't want to get ill. You don't want to go to courts also because you don't want to get trouble, because once you are going to court, the court discussion and the litigation will go on for years together. It will be trapped. And then third, police. We are also having a fear in the mind. oh my god, I cannot speak anything against police. In case there is something wrong, they are always right. Because of fear, what if the person will not take legal action? And that is what is one of the important points. And because of that, the doors of the courts are technically closed for them. No, haven't you observed this many times, that because the person is not having access to the courts, the doors are closed, and then there is no other recourse, and therefore this particular rule is coming into entry. So what is the philosophy behind the liberal principle? I told you that why the court has to liberalize the principle. I gave the example. There are hundred of cases which are there. I have identified few of them which have been put into later part of presentation, that judges have interpreted Article 21, Article 32, Article 136 also, and then they have interpreted, and then that's why there is a liberalization of the rule of locus standi. I told you reason, that there is a poverty, ignorance, we discuss, high cost of litigation. You can understand this point. Let me give a simple example. It may be very personal, it may be very specific, but I will tell you. You know that it's a latest development yesterday only. If any one of you are aware that yesterday, the day before yesterday, the net examination was conducted in India, that national eligibility test. How many of you have heard about this? What's the news about net examination? Yeah,
Sir, it has been cancelled because there have been
exactly.
speculations that the integrity of the exams might have been compromised.
Exactly. The same has happened with the NEET also. Now you take example. I am telling you it's a glittering example because in some of the academic discussion today only, be ready that some of the petitions will be filed in court of law on behalf of the students, and one of the ground would be that, sir, the net examination was absolutely important for the people who are willing to write exam and then selected for assistant professorship, lectureship. They would have prepared for a year, they would have traveled from the destination for appearing in examination, and suddenly when examination has been cancelled, what will be the cost and what will be the damages which has been suffered by them, and why they should not go to court in order to hail the government or the institutional liable, that why you are so relaxed and why you are perplexed, why you are not paying attention to the sanctity of the exam. Can't you send relation? So be ready. Some of the academic discussions are right now going on the social media on a very, very furious manner, that people who are not happy with the cancellation are there. Now, why I'm linking with the High Court of Examination litigation? Let me give example. I am the one of the person who actually could not get satisfaction. Now, can I challenge this before the court of law? If yes, which court to go, how I should approach, and what amount I need to pay? You might have heard that simple petition. We are not here personalizing the advocates' practices. Obviously, this is under the Pro Bono Club, and I'm very happy that Legal Services Committee Pro Bono clubs are doing wonders, and there are a lot of advocates also who are coming at the rescue. But generally, we have seen that advocate approach and hiring advocates, drafting petition is something which is very high cost, which a poor person cannot afford. Forget about poor person. If a middle class person earning few thousand rupees from the job is also unable to afford this money some of the time, because the amount get in lakhs, right? And therefore, if a person literally afraid, now I am a person who is recently has passed LLM examination, I am appearing in that examination tomorrow, I want to be a professor, lecture somewhere, and this is only my resort, that if I am positively passing it, at least this is qualification, based on that I will be able to earn some of the livelihood. And today if I want to challenge this, I want to get money, I won't be able to go anywhere. And that's not only case of examination, that's case everywhere. You are not getting your fundamental right relating aspect, you don't get food, you don't get some good kind of the civic facilities. How you will go? Cost of litigation is a big question. Democratization of the justice is also reason, because justice should not be done, justice should be seen to be done, that we have heard. So how the justice will be there? So that is also important aspect together. Redressal of the public injuries and avoiding plurality of the litigation. Now take example of the net only. Public injuries are there. Now, how many people would have written the examination? The number would be in thousands, right? Now, imagine that there is no mechanism like PIL. And in every high court of state, 1, 2, 3, 4, or 100 applications are filed for claiming compensation, for holding some authority liable, for claiming the redressal. How many litigation would be filed in a different high court and even Supreme Court of India for the same matter? Won't it be a good idea that one single petition is heard by competent court, and that petition is giving redressal to all the people who are affected? If yes, then the best example is coming in form of the public interest litigation. I got you. So avoiding plurality of the litigation, that's important. Take the example of the hundred of so many classic examples of public interest litigation. I think Kalpesh sir has come out with a compilation of the selected cases also. Many of the cases are public interest litigation cases. Sir will always share this particular knowledge with you. And you take example that the right to environment, right of clean roads, right of livelihood, right against them of the public damages, right to get a protection in jail from the torture. Now, this is not matter connected to 1, 2, or 3%. It is matter connected to thousands of people who are in jail. And that's why don't let anyone go into the court with petitions. Let someone else come on behalf of all, and justice will be done. So that's some of the wonderful provision, wonderful idea which is behind the public interest litigation. And last one, curbing executive access and ensuring a responsible government. That's an important point. Why we have selected to be a democratic republic state? Why? There would be monarchy, there would be system like dictatorship. And today also in many countries, you find out that it's a not democratic government. So the moment you select the democratic government, we are always expecting that the government will be responsibly work and will get what is our entitlement is. And in case it is not there, IPA, public interest litigation, can work. And that is what, this is something very important, which generally is a subject of the LLM. I'm telling you that when we were part of LLM, 2 years LLM, there is a one specific paper it was required to be studied. That's a judicial process. Today, the nomenclature has changed. We do 1 year LLM, and therefore this kind of topic may not be discussed, but that's a broad concept of judicial process. Now, if you bifurcate judicial process into broad dimension, one is a judicial activism, another is a judicial review, and third is judicial self-restraint. I don't know how many of you are aware about that. Judicial review is already part of constitution. We have heard about that. This is directly available. Like judgment of the lower court is always possible to be challenged before the higher court. And that too, our Indian constitution have the judicial review of the legislative action, judicial review of the executive action, and judicial review of the judicial action. I hope this is getting clear to you. You have seen the petitions which is reviewing the legislative action when law has been unconstitutionally passed, when the executives have failed, and judicial action. This is very clearly available. But this is what the judicial creativity, that when there is an absence of law, judges will take a particular cause and particular step, and this step will result into protection of law. Now, best example here is a Vishakha judgment. I'm sure you might be aware about that in 1997, when matter is coming to the court, and it surprisingly, there is no legislation, there is no legal provision which is protecting women who is working and from any harassment or sexual exploitation. The court is reading CEDAW, that is International Convention, which is signed by India also. That convention for elimination of all kind of violence against women, which is signed by India. The convention is making liability on the shoulder of employer, and judicial decision is coming in the year 1997 that we are making this judgment that all the responsibility should be on the shoulder of the employer, and you have to always take care. In case any complaint is there, in case any harassment takes place, the employer shall have to take a call and have to redress that. Finally, in 2011, the bill was passed, and then 2013, the act came, which is called as a POSH Act. I am sure all of you have got a training on POSH Act. If not, just read this particular legislation. This is judicial activism. So judiciary is always coming by virtue of interpretation of the various provision. Bottom line of the discussion is that judiciary has time and again said that we are here as a guardian of Indian constitution, and you cannot expect judiciary to be silent when the rights of the people get violations. So entire PIL jurisprudence is a part of the judicial activism. This point, I think we should always keep in mind, that there cannot be a over encroachment of the rights of judiciary over parliament as well as executive. This responsibility is always taken care by the judges so many times, and that's how some of the matter you will find out judicial self-restraint. Now, this may be a very familiar word to many, maybe not familiar to some of them. But what is judicial restraint? Read the judgments where courts has told that don't come to us. The best example of this, can anyone give the example of the judicial self-restraint, please? If you have heard about any case which falls under this category, judicial self-restraint, court says they don't come to us in every matter. We are not able to help in this matter. Sorry, let's wait and watch. Any example, please? What about the through criminal laws Any idea about the PIL or any litigation which is filed before the three criminal laws? And what is the observation by the court? Yeah, in case you are following what court has said, that three criminal laws which is there replacing IPC CRPC Evidence Act, and from just few days after, next week onwards, 1st July, the government is planned to implement that. Petition have been filed in Supreme Court of India. One of the biggest ground was that when these three bills were passed in December 20 and 21 2023 in Parliament, most of the opposition were not there. They were walked out, and in absence of them, the bill has been passed. This is one of the ground to challenge. What court has held, that don't come to us before the law is implemented. Your matter might have content, but this is premature litigation, because let the law implemented, and when there is a flaw, then only come to us. So this is one example. There are hundred of example. Our subject is not there, but I'm simply bringing your attention that judiciary also have this aspect, that when, and ultimately we can understand that would it be, I'm just giving you thought, food for thought. You don't need to answer it today, but you can always think on that we have not judicial democracy, but we have parliamentary democracy, right? So our government we call parliamentary democracy, and therefore a lot of learned people have asked this question, that how far it is advisable that every law is made by the judiciary only by pronouncement of judgment, and why you need judgment law rather than the law made by the parliament. This discussion is always coming into preview, and therefore this is wonderful idea that judiciary will always restrict themselves, will not entertain this matter. And therefore I told about judicial activism, that is a proactive played by the judiciary for rights and liberty protection, and which is normal adjudication move also. Now, root of PL is under the justice, social, economical, and political justice, which is enshrined in Indian preamble also, as well as the important provision also. So these are the some of the point. Now, you might have heard about these cases, Hussain Ara Khatun versus State of BR judgment. What happened in this case? The inhuman condition in prisons, and ultimately more than 40,000 prisoners are there. And therefore, the court is taking cognizance by virtue of the judicial activism that right to speedy trial, even though not expressly mentioned into Indian constitution, is a fundamental right. And therefore, this is the glittering example of the public interest litigation entertained and properly disposed by the court of law. These all cases you might have heard, so I'm not repeating all the content of the case. I am bringing your attention to some of the aspects. Sunil Batra versus Delhi administration, wonderful judgment where a simple postcard or letter written by one of the prisoner is converted into a petition called habeas corpus, and it has been entertained suo moto by the courts, that even though there is no petitioner directly available who has drafted a petition, will take it, and therefore the judgment has been passed. So this is the example, that when a letter has been converted into PIL and judgment has been passed. I'm sure many of you, and in all law syllabus this judgment is always discussed. Then third is SP Gupta versus Union of India judgment, that any member of the public or social action group acting bona fide can invoke writ jurisdiction under 226 to High Court and Supreme Court for redressal against the violation of the legal or constitutional right, who does not have social, economical, or any disability. By this judgment, PL became a potent weapon for the enforcement of the public duties. So SP Gupta judgment is also wonderful judgment where the PL has been spoken about that. Now, there are few other important judgments also, but we'll consider this point a little bit forward and then we'll go. So, ultimately, we have heard or we have understood nowadays or till the discussion that public interest litigation is not expressly defined in Indian Constitution, but it is a judicial creativity under the judicial activism. And when court has taken a cognizance that when the matter is connected to public at large, we will entertain. Now, we'll go a little bit formal and practical aspect, that where you can file the petition. You can go to Supreme Court of India in case there is a violation of fundamental right, Article 32, and in case you want to go to High Court of States, you can invoke 226. Let me tell you, we always say that jurisdiction of High Court is wider than Supreme Court of India. As we have heard, that public interest litigation may be filed before Supreme Court only for fundamental right violation. But in case of other legal rights violation, PILs are also filed and they are also entertained by various high courts of the state, because it is not only for fundamental right, but it is also for the other rights. So this is the very important point, that you can go to Supreme Court and High Court. Now here you take example. I'm sure all of you might have seen the movie Jolly LLB, right? Have you seen Jolly LLB word, Jolly LLB movie 1? What has been a big flaw of Jolly LLB movie? We teach the examples of the movie in classes, right? When we discuss. So Jolly LLB 1, when that, wonderful PIL is filed before the district court, that's one of the flaw. That happens in a imagination in movie only. Otherwise, the PILs are always starred in a thing. So here, fundamental right and other rights are required to be kept in mind. As we have already heard about the fundamental right, I am not touching this portion, but please keep in mind that whenever you are filing, this point will continue tomorrow also. That when we will learn the drafting of the petition. But before we discuss the drafting, I am just clarifying some of the points that properly we need to connect that how your fundamental or legal right is getting violated by virtue of the action which might have been taken by the legislature or executive, and therefore thorough understanding with fundamental right and its implementation is must. So for your kind information, you can always do that. Section article 30 12 to 35 of the Indian Constitution, which is part 3, is always giving you the fundamental rights. Definitions are there in 12 and 13, and article 14 to 35 talks about the fundamental right. Different categories of the fundamental right we have, which has been explained here: right of equality, right of freedom, right against exploitation, right to religion, and cultural educational rights. And these all rights are not sufficiently protected unless and until you invoke the article 32, which is a right to constitutional remedies. So just I am sure that you are aware about this fundamental right. This is only for your understanding. In case you have any doubt or in case you are not able to understand, you can unmute yourself or you can ask, or you can put in comment chat box also. So I'm quickly going hurriedly and I am simply going the important provision which I have brought here. Now, this is something important. Article 21. As I told you in the beginning, that imagine the situation where people are completely having no access to some of the things which are required to be there with them to live properly. And then the interpretation has been available by the Supreme Court of India. So I have linked some cases also here. I will explain some of the cases. So article 21 of the Indian Constitution simply provides no person shall be deprived of his life and liberty except according to procedure established by law. Now, for a kind information, you can see the important point that in our fundamental right, many places citizen is mentioned, many places person is mentioned. Now, you take example of Article 19. Article 19 have availability with the citizen only, right? Article 19, you read, it is connected to such citizens, so only citizens can avail. But article 21, you will find out that the person word, which is wider connection, is available. So when Supreme Court is read this particular article, and then based on that, how many rights we have got, this is the list of rights which according to Supreme Court identified as a part of the fundamental right. Supreme Court said right to live with human dignity is part of article 21. Right to livelihood, Olga Telly's case, wonderful judgment. Right to education, you cannot expect that person will live the life meaningfully without having education. Education opens the door, it opens the wisdom, and therefore it is also held to be a fundamental right. Right to privacy, which judgments will come into picture here. Take example of the Aadhaar judgment, latest one, Uputtu Swami case, where right to privacy is also considered to be the part of fundamental right, which is simply it reinterpreted again. Right to travel abroad, we remember the Maneka Gandhi case. Right of speedy trial, under trial prisoner, because when a person is in a jail behind the bars without having a fair trial, it is actually violation of his right to life and liberty. So Supreme Court, this all are PILs, writ petitions filed by the people at some point of time resulted into some of the wonderful judgment, and we are able to understand that here. Right to clean environment, MC Mehta is a wonderful example here. Said right to clean environment is also there. So once upon a time, even you remember that after 1972, we could see that different academic institutions and different boards included environmental law as a subject. Earlier, environmental law was not at all there, and later on, multiple times when Air Act came, Water Act came, Environmental Protection Act came. Right to clean environment is also fundamental right. Right to food, right to health, right to get free legal aid, that was also considered to be the fundamental right, and that's why later on you see the National Legal Services Authorities Act, right against inhuman treatment, right against sexual exploitation. This all are glittering example where number one, person is not single who is affected. This all cases you will find out hundreds and thousands of people. Number two, this person individually is unable to go to court because there may be poverty, illiteracy, high cost of litigation involved. And number three, on behalf of them, any one person would have taken a lead and would have gone to the court, and then court would have given judgment on behalf of everyone. And therefore, this wonderful jurisprudence of the public interest litigation we have developed in our country, which we are learning today, right? And finally, right of writ petitions. I am sure all of you are aware about writ petitions, which writ petition can be filed in what cases. Generally, which kind of writ petitions are selected in PIL? Yeah, can anyone unmute and let me know? This is common, even in 226 also, these petitions are available, right? So generally, habeas corpus comes in what cases? For a kind information, we have subject advanced legal drafting at GNLU, and all kind of petition drafting. Generally, we are understanding, okay, writ petition drafting is sufficient, but we take care about all minute things also. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. In what cases it will come? Do I have anyone who can unmute and tell little bit, please? Yeah. Habeas corpus will come in what cases?
Cases of illegal detention.
Wonderful. Yes. So see, whenever you are able to identify, whenever you draft this particular habeas corpus is not bail application. So generally, in case you are not aware, we have seen the drafting. It's not about bail. It's all about appearances. Widest kind of thing. Okay, why? Because mandamus generally in all period of mandamus selected, because mandamus is the widest government. It is against the non-government also. So judicial body, tribunal also, government also. Government has not enacted the law, or government has not done something which they should do, mandamus lies. When government has done something which is not true, then also mandamus lies. But mandamus also includes the tribunals as well as courts. But when you see prohibition and certiorari, these two writs are only court specific or tribunal specific. You might have heard prohibition comes in what cases? When the matter is already running before the lower court or lower tribunal, which is having quasi judicial authority, and because of the running of the matter, your rights get violated. You want to stop this particular thing, and then you want to take the action, or you want to prohibit the person to take a call, writ of prohibition lie. And certiorari is there when the matter is required to be quashed, right? So and certiorari, this both is against the lower court and judiciary only, but mandamus is against all of them, and that's what generally we prefer mandamus. Quo warranto is also being limited scope when there is a the person by what authority they are holding the particular position. So these all writ petitions are very interesting. There are wonderful books written. You can always read that in minute thing, and you can always think. So now why PIL is very much important, as we have seen, it is giving common people access to the court to oblige legal redress. As we have seen, it is a wonderful blessing for many. It's an instrument of social change. Why I say the word instrument of social change? Because there are many things which ultimately not entitled, or even though it is entitled by the people, it is not given to them. And even though it is given, it is as a particular obligation. Let's see, we are giving you, like take example, that government has passed the law that you are entitled to this benefits, and then officer or the authority will make the people oblige, then this is coming in form of them. I gave example of the free or food or subsidized rate of food. There are multiple schemes which is started by government. So in case the government is not entitled, is implementing them, the PIL and use of PIL and judgments which are delivered against the government officers and people court are making them work, is actually working as a social change. And then justice is required to be served. To make a justice accessible to poor and marginalized, as we know that poor and marginalized people is always required to get the protection of rights, and therefore the PILs have worked in a tremendous manner for them to make human rights those who have been denied rights, to democratize the justice, to judicial monitoring of the state institution, various institutions who are monitoring. State institutions means institution which are under Article 12 of Indian Constitution. Tool for implementing concept of judicial review. Judicial review, we have seen that judges has always right to take a particular view or to see whether they are working properly or not, and therefore the PLs are working, and enhance public participation judicial review of administrative actions through PL. So these are the few significant aspects. Now, what are the example of the successful PLs in India? I have given some of the example. That speedy trial, equitable justice for under trial prisoner is a wonderful observation of the Husainara Khatun case. We spoke about Vishaka versus State of Rajasthan, which has provided the sexual harassment of the woman at the workplace should not happen, and this has subsequently resulted into the POSH Act. Then Permanent Katara versus Union of India, medical treatment in case of accidents. I am sure that you might have heard about this case. You see, whenever any accident happen on the road, what happens that if anyone is bringing person to the hospital, and if because of that any evidences are tampered, court or police ex-police people are harassing those, and therefore one situation came that people were not ready to touch the dead body or to touch the injured person because they are afraid from the police. Paraman Katara wonderful judgment that irrespective of what, you should always give medical treatment first, and then ultimately police action or police will not be held anyone liable just because they have helped it. So that's a wonderful judgment which has come because of that. Then Sila Barse versus State of Maharashtra, the custodial violence against the woman in prisoner. So when women prisoners are jailed, believe me that when state machinery including police is there, which has very powerful boundaries, and inside the prison if some violence will happen, where you will go. So this PL has resulted into wonderful guidelines that how women should be treated in a prison, what should be the separate cell, what should be the lady constables and lady officers into jail. This all is a development for that. The 2G also, right? It's a wonderful judgment in 2012 where the allocation and the irregularities came and ultimately led with the many political parties and judge and different kind of the politicians also scrapping everything is also a successful example for that. Then Bandhua Mukti Morcha case, child labor till today is the prevailing child labor because of the population increase, because of the poor people who have many children. They will find out that entire family is working and child labor is very prominent. That should not be happening, and dangerous kind of the evocation should be always away from the children. Then Olga Tail is right to livelihood. There's a wonderful judgment, Bombay Municipal Corporation, where the hawkers are completely deprived or completely taken away or removed from the streets. That fundamental right is also there. The same thing has happened in Ahmedabad also. I am in Ahmedabad. So in Ahmedabad we have riverfront, and on the riverfront there is called Gujri Bazaar. That's market which is taking shape every Sunday, where a lot of small vendors, small hawkers come and sell the things at the affordable rates. And when riverfront got developed, all the market and people were completely removed. Then matter went to Gujarat High Court, and High Court makes sure that the Gujri market will not get disturbed even though the riverfront is working. So that same thing has happened in Ahmedabad also. Then State of MP versus Narda Bachao Andolan, rehabilitation resettlement has also come out with the wonderful provision. So when there is a Narmada River case, I'm sure very very popular judgment is there, where the people who were part of the catchment area where reservoir Sardar Sarovar Dam reservoir is getting constructed, thousands of people will lose their particular livelihood as well as the residential places. They have the fundamental right of resettlement. So please do that. That has been one of the judgment. Then Harshad Prabhari versus State of Gujarat, protection of the identity of the HIV positive patient. I don't know whether you have awareness about the judgment or not, but nowadays, if person is HIV positive, their identity should be kept not so open. The way you might have seen that whenever any particular you can say the matter is happening about the women and about outraging modesty of the women or rape, the identity is not revealed. The same thing is judgment given by the High Court also by virtue of the PIL, that they should not be revealed their identity and they should be given the medical benefits or medical treatment without revealing the name. Then Lakshmi version of India is about acid attack. You might have seen the movie Chapak, right? So acid attack, you might have seen many examples that when there is a love, there is an affair, and when one of the lady is not, say for example, ready to stay with the boy, many times they will take a revenge, and revenge would be, I will completely destroy your face. So acid attack victim protection, that's a wonderful case of Lakshmi versus Union of India. Then Then MC Mehta. I will request Kalpesh sir to enlighten people by your wonderful, compilation. Taj pollution case, Ganga pollution case, vehicle pollution case, oleum gas leakage case. These are the wonderful judgments. I'm sure all of you have read the Taj judgment. In case it is not, read the judgment. It's a wonderfully written judgment, Taj trapezium case. And so bold orders have been passed against the all the industry which were using different kind of the fuel, and then the fuel was resulting into emission of the gases, and gases were resulting into acid rain, and Taj color or the entire marbles of the Taj were getting converted into yellowish color. This is one of the landmark judgment which is making the government liable to rehabilitate all the things. So this is the example. As this case are so interesting, it will take again an hour in case we go into detail, but these are the example of the successful PIL. Now if you read these judgments, they would explain all the concept that how PIL and how the person who is not even directly coming from the affected family. Now there is no necessity MC Mehta is standing or staying on the river bank of Ganga, right? But yes, there are thousands of people who are getting affected because of the pollution, and he has filed the petition on behalf of them. Vehicle pollution, which is resulting, then Vellore Citizens Welfare Forum precautionary and polluter pays principle. You must have heard about this case. Environmental case, subject is incomplete without the discussion. So if you are polluting, you have to make should be liable. Then importance of hazardous waste. There's a research foundation of science, technology, and natural resource policy. Is a judgment. Then solid waste management, firecracker noise pollution case. These are the series of judgments which are there on behalf of the people who are there. So these are a few of the cases only which we are discussing. Finally, as we have seen, concluding the discussion, PIL is for public interest on behalf of those who are unable to get justice. But there is also example of the misuse of PIL. Now, as I told you, human beings are always considered to be greedy. I will conclude the discussion with a small story. Now, the story is about the city. There was a city, and the city is actually at the outskirts of the forest. So there was a big forest, and having lot of snakes and lot of forest and wild animals residing. Now, every time from jungle, some of the snakes were entering into city. So there were so many houses where dangerous poisonous snakes were entering, and these snakes were actually biting some of the people, and people were not happy. So people went and requested to the government that please do something and kindly help us to get a read from the snakes. Now technically what government should do, government should tell the officers, but then it was not possible. So someone suggested that government should come out with the policy, and there after consultation government come out with the policy, and this policy was declared that whoever will catch the snake and the snake will be deposited to government zoo will be rewarded. So instead of helping people, instead of appointing authorities, government make a policy reward. Now the moment this policy got reward, people got very happy. So every time if any snake is entering, the people voluntarily got the snack catching sticks, catching it, depositing government, and getting the reward of 100 rupees. Now within few months, entire city became snakeless. No snake was found. So I'm sure that you would be thinking that now matter should be sorted, but no, matter got aggravated. After so many months, people now got acquainted and habituated to catch the snakes. So they started going to jungle, catching the snakes, and again started giving to government and started taking 100 rupees. There also went for some months. After some months or a year, entire forest becomes snakes free. Now what to do? So later on, people started approaching the zoo owner who was keeping the snakes, and they started buying the snakes or small eggs of the snakes from the zoo owner, started taking to their home, nurturing the snakes, and when the eggs are fertilized, and then when the few small snakes are growing, again they started the business. So systematically the trade of the snakes started, and it went to black kind of trade also. Finally, when government observed, they cancelled the entire particular scheme and told that now you do whatever you want, you are not going to give result. Why this story? This is the glittering example that when there is a provision of benefit, there can be misuse also. And in few years, it has been observed that some of the PLs are fined for publicity, some of the PLs are fined only for private interest, some of the PLs are for political rivalry, and some of them for any oblique motive. So publicity interest litigations are there. So when actually there is nothing wrong in a law, but just in order to get the publicity, you want to get viral, and therefore you are going to court and you are willing to get any judgments. Private interest, public interest is very much. This point I will clear tomorrow. That what is the difference between public interest and private interest? Public interest is something which is affecting to public at large. But when there's a dispute between two people, not necessarily connected thousands of people, but you intentionally club it as a PIL, this will not be filed. And therefore, court took a main cognizance, and therefore nowadays Supreme Court of India and all the high courts from their 2010 come out with the guidelines that what should be considered as a PIL, how PIL should be filed, what should be the content of the PIL, and what will be the cost if you are filing the PIL, which is the fault. And this discussion, I think, time is telling us that you should carry forward tomorrow. So I think we will wait for a few more minutes. I think sir has mentioned that the class was 6:30 to 7:15, but I'm sorry I have extended the time limit. But again, I would stop here and would like to get some questions, queries from your end. And yeah, in case you have anything to ask from the discussion today, you can definitely tell me. We will be able to discuss few things, and then we will conclude the discussion and we'll meet again for a next session tomorrow. Yes, anyone who want to have any idea or any kind of query question?
Somebody has dropped a question in the chat box.
Sir, we have a question in chat box. Shaista,
Yes, how can legal framework be strengthened to prevent frivolous and political motivated cases from diluting impact of it? Yeah, this is wonderful question, and judiciary is struggling with that. Now, legal framework is very difficult. There is no law, but yes, tomorrow I will show you that Supreme Court of India and various High Court has come out with the guidelines, and before the PILs are entertained, they are always checking that whether it is a politically motivated PIL or it is a public interest litigation. So today the system is not by the law, but it's called judge-made regulation. The courts have come out with the regulation. Accordingly, it is getting ideas. Yeah, any other question? Yes. Yeah, any other question? Yeah. How does the judiciary balance individual right against the collective societal interest in PL cases, particularly when this interest conflict? Yes. Judicial and individual rights against the collectives. See, as we have discussed, and I will also share, this judgment you can see here, like take example of the MC Mehta judgment, right? Where there is a question about the rights of the families of children, right? Similarly, there is a case about I will tell you that I am in Gujarat, and there is a question of the cattle on the road. There is a question about the construction of the public roads, etc. Now, in this case, PILs have been filed, and whenever these PILs are filed, the judiciary will always say that whether this particular thing is actually affecting, and therefore, tomorrow's drafting session, I will show you the actually drafted and filed PIL, in which these all things have been mentioned, that it is how it connected, who has filed, how it is connected with the public cause, and what are the other repercussions. So that's the biggest call, and that's how judicial discretion come into picture. So as you know that many things in our country is left on the judicial discretion. In PL also it is left on them, and then accordingly it is taken into consideration. Right. Any other question? Yeah.
Sir, difference on PIL and social action litigation, please, sir.
Sorry?
The difference between public interest litigation and social action litigation.
See, there is no actually, we have concept of the public interest litigation only. In a very normal normal word, we are using the social action litigation. But generally, the action litigations are always filed in form of the PIL. Generally, people are bifurcating them, that there is some social cause, government want to have a proactive role, and on behalf of the society, we request you that please make a law. So then you put this kind of thing into social action litigation. But in public interest litigation, there is something bad, something wrong, government has disastrously failed, and you want to import. So this kind of bifurcation is tried to be given by some of the experts. But as such, law not making any difference. It's all about the different names we are giving for the petitions filed for the interest of the people at large. Yes, any other question? So I will share this presentation to you. And again, tomorrow we have time for discussion on the drafting portion of the PIL. I would love to share some articles or some of the material with you. You read it tomorrow before you come to the class, and that will give you idea that how actually PILs have been drafted and what the judgment have been given by the court based on that, right? So I think we'll continue the discussion tomorrow, sir. With your permission, we can end.
Okay, sir. Then let me conclude this.
Yes, sir.
Thank you,
Please.
thank you so much, sir, for this knowledgeable session on the pill. I am very optimistic that our participants have benefited from this session. Truly speaking, I was myself, sir, very desirous of participating in your session on pill, because prior to this, I have once participated in a certificate course on legal aid and trial laws, in which you discussed the various dimensions of pill. And so we will again meet tomorrow with a new session, sir. So we are very thankful to you. I and my team is very thankful to you that you, upon a short notice, you accepted our request and you spent your precious time with us. And we greatly benefited from this session. Thank you so much, sir.
Yeah.